Yes, Ms. Proops.
The court invited me to answer the question of what the legal effect of the form was. The answer...
Hang on, just wait for the door to close, because you have the misfortune to be seated in the back row, which means that you need to speak up a bit as best you can. Yes, good.
The court posed the question as to the legal effect of the form PF10. The answer to that question, as we see it, lies in Rule 4, 2 and 3, which is page 197 of the White Book. In summary...
Hang on, don't go too fast. I know you're trying to get through your submissions, yes. But...
What was your White Book reference again?
It's 197, page 197, and it's Rule 4, 2 and 3.
Page 197.
Yes.
Forms.
Yes. So if you look at 4.2 on 197, forms approved by the Civil Procedure Rules Committee as published online and available for downloading must be used in the cases to which they apply. If they haven't been approved, we see from subparagraph 3 that they may be used as appropriate. Then try to research the question of whether this form was approved. In the time available, all we've been able to discover is that there was a committee meeting on the 7th of March of this year, where the minutes contain a reference to the committee potentially amending the form. The minutes record it was agreed that no changes were required at that time, but the committee would keep a watch.
That was in light of Mr. Justice Nicklin's judgment, so it doesn't answer the prior question.
I'm afraid that's as far as we've been able to get as to whether it is an approved form or not.
No. Since I'm chair of the CPRC, it should be possible for me to find out.
I'm grateful.
I wondered if Mr. Weir knew. Do you know, Mr. Weir, what happened? Can you remember?
No, well, it seemed to materialise sort of out of thin air. I think it's obviously an adoption initially.
No, that's fine. I didn't want to. I just thought you might have the answer and
no,
have remembered committees at the time or whatever. Thank you.
And just before I come back to the Dartford issue with which our intervention is concerned, I am conscious that the court is keen to know what our position is on the wider issues. For the reasons I've explained, I'm not sure I can properly assist you on the wider issues, other than to say that PIBA would have a serious concern about the speculative prospect of an approvals process being used as a springboard for obtaining anonymity from the outset of the proceedings, on the basis that that seems to us to risk an unwarranted interference with open justice in circumstances where ultimately there may be no approvals process, and given that there may well be cases, and potentially very many cases, where on the facts of the case the balance tilts in favour of the litigation being conducted on a named basis, unless and until it is settled and the approvals procedure comes into focus. And if ultimately the goal is to protect privacy in the context of the approvals process, as we've suggested in paragraph 27 of our submissions, as we see it, that can be readily done by making an application for anonymity once the settlement agreement is in place that requires approval by the court.
I mean, I completely don't get any of that. I mean, the situation, if you have a severely damaged and vulnerable claimant making a personal injury claim and clinical negligence, and they are going through the process, which we're told in, say, 90 or 95 or 97% of cases will result in an approvals process, surely if it's going to be appropriate to anonymise that person's name when you get to the approval process, it might well be appropriate to anonymise them at the beginning.
Yes, it might be. And there may be very many cases where anonymity is warranted from the outset on the facts of the particular case. The point that we're making is that insofar as anyone is arguing that there should be a blanket approach where anonymity is warranted from the outset, because many of these cases end up in approvals proceedings.
As in Dartford.
as in Dartford.
So you say Dartford not applicable before approval. If no anonymity before approval, cases are dealt with on an application in accordance with the usual practice.
Indeed.
Right. Well, that seems obvious to me.
Yes. So that's simply the position that we're adopting, because it's not clear to us that others aren't venturing towards that approach.
You would also say, I think, that the evidence requirements of Part 21, whatever it is, 9, 10, 3, is not applicable in that situation.
No.
No. Okay, good.
And just to finish the point, we say that automatic preemptive reliance on a possible prospective approvals process as justifying anonymity across the board in all cases would constitute an unjustified expansion of the Dartford principles in a manner that was certainly not contemplated by the Court of Appeal in Dartford. But if I may, I will now focus on the judge's criticisms of the judgment in Dartford very specifically. But before I examine where the judge went wrong in his analysis, it's important that I make clear that we agree with the judge to this extent. First, our position is that it's illogical, and in this respect we agree with the judge, for protected persons seeking anonymity in respect of approvals proceedings.
Sorry, you've got to either take it a bit more slowly or speak up, or both.
Yes. So the first point is that the judge made clear in his criticisms of the Court of Appeal's judgment in Dartford that the Court of Appeal went wrong when it said that protected persons who were seeking anonymity in respect of approvals proceedings should nonetheless be named in the cause list.
Yeah.
The judge made the point that that doesn't work as a matter of logic, because you're effectively putting into the public domain that which is sought to be protected. We agree with the judge on that issue. And our position, as you see from paragraph 27 of our submissions, is that there should be a protective approach that's adopted, whereby the individual is not named until such time as the court determines that for whatever reason anonymity is not warranted.
So after the application for anonymity is made, there's a sort of pro tem direction, is there, to anonymise,
Yes.
even though that is an inroad to open justice and all
Yes.
the rest of it.
Yes.
But you do that as a pragmatic way round the corner.
It is typically what happens in the context of misuse of private information cases, where there is effectively a protective application that's made before the claim is even issued, and then the court considers the question of whether the anonymity should be maintained at the first hearing.
It's just an example of the class of case we were looking at earlier, isn't it, where the procedural mechanisms must be such as to preserve the substance of the right that's being claimed.
Quite. And so we agree with the judge on that issue. And also, to the extent that the judge was seeking to make the point that derogations from open justice should never be let in on the nod through some sort of blanket, automatic, unthinking process, we also absolutely agree with that point as well. For our part, this is an area where a blanket rubber stamping approach is never going to be lawful. These applications, we say, will always require proper, meaningful judicial scrutiny with an eye to the particular facts and circumstances of the case. However, we also say that the Court of Appeal's judgment cannot fairly be read as approving an automatic rubber stamping approach in favour of granting anonymity. Instead, as we read the judgment, it proceeds rightly on the basis that because of the unique context of the approvals regime, it will normally, albeit not invariably, be the case that the balance of interest tips in favour of granting anonymity. So as my lady pointed out earlier today, the Court of Appeal is not ruling out that there may be cases where a different approach is warranted, meaning in effect a case-by-case approach has to be adopted. The Court is very clear that there is no iron rule that applies in this area. But the Court of Appeal's position is that anonymity will normally be justified because of the unique context presented by the approvals regime. And that point really takes us to the crux of the matter, and the crux of our criticism of the judge's analysis in Dartford. Of the judge's analysis of Dartford. Because as we see it, where the judge has gone wrong in his analysis and in his criticisms is that unlike the Court of Appeal in Dartford, he has, with respect, altogether failed to grapple with the very specific factual and legal context of the approvals regime, and the ways in which that regime, if not properly safeguarded, may perversely end up harming the very people it was designed and intended to protect, unfairly putting them in a worse position than that enjoyed by capacitous litigants who do not have to expose their private settlement business to judicial scrutiny. And as to this, it seems to us very important that nowhere in the judgment does the judge attempt to engage with the protective nature of the jurisdiction, which the court was concerned with in Dartford, and how that jurisdiction differs both from the court's ordinary civil justice jurisdiction and its criminal justice jurisdiction, which was, of course, the jurisdiction that was in issue in Re S. And nor does the judge meaningfully engage with the ways in which the 2110 regime, if not properly safeguarded, would expose vulnerable people to adverse privacy consequences, which capacitous litigants can readily avoid, thus inevitably producing perverse and indeed discriminatory effects. And yet that context is, we say, surely absolutely fundamental to how the balancing exercise falls to be approached in approvals cases. The reality of the Dartford judgment is that the court was not focusing on rival generalities, and nor was it creating a presumptive priority in favour of Article 8 rights, and nor was it reversing the burden of proof. Instead, what the court was doing was what it absolutely should have been doing, which is recognising the particular and fairly unique legal and factual context within which the balance falls to be struck in approvals cases, and recognising the ways in which that context will normally, albeit not invariably, tip the balance in favour of granting anonymity. And it's perhaps just worth noting here what the judge said, the judge below said at paragraph 41 of his judgment, at page 284 of the core bundle. What the judge says in paragraph 41, in effect, is that there will be a clear presumption in favour of open justice because of the context in which the balance is being carried out. He says that doesn't amount to giving Article 10 rights presumptive priority, as opposed to merely recognising the context in which Article 10 rights fall to be considered. Well, what we say is that the context is also inevitably important when it comes to considering the weight to be afforded to Article 8 rights. As we see it, the Court of Appeal was not giving presumptive priority to Article 8 rights, but was instead simply rightly recognising that because of the context created by the approvals regime, in the ordinary run of cases, Article 8 rights are likely to be the preponderant right in the balancing exercise. And by the same token, the Court of Appeal cannot be said to have been focusing on rival generalities, but rather on the particular and particularly problematic dynamics of the approvals regime, and how those dynamics engage and conflict with Article 8 and Article 14, conventionalised, certainly if not properly safeguarded. Equally, the Court of Appeal can't fairly be said to have reversed the burden of proof. Instead, what it was doing rightly was recognising that in the ordinary run of approvals cases, and because of the particular dynamic of approvals cases, it will not be difficult for protected persons to discharge the burden that they unquestionably bear of showing that their Article 8 right not to be identified in respect of the approvals process outweighs any countervailing Article 10 rights. And pausing there, we've noted the judge's conclusion that anonymity can be justified where that's necessary to safeguard the administration of justice. See paragraph 34 of his judgment. Well, what about where the absence of protective orders would conflict with the protective objectives which the court seeks to achieve when exercising its protective jurisdiction under 2110? See further on this issue the Supreme Court's judgment in Abbasi at paragraph 61, which is tab 4.35, page 1245. In this paragraph, we see the Supreme Court highlighting the importance of the court being able to restrain acts of publication that may in themselves threaten the effective operation of the court's protective jurisdiction, which in turn amounts to threatening the effective administration of justice. Paragraph 61 of the judgment in Abbasi. Well, if publicity would result in a situation where the exercise of a protective jurisdiction ended up harming the interests of the person intended to be protected by perversely stripping them of privacy protections they would otherwise enjoy, that is surely a classic scenario in which, all things being equal, you would expect the court to make orders preventing that outcome to ensure its protective jurisdiction was exercised in a protective rather than a harmful manner. Standing back from the detail, what the judge seems to be doing, and where we say the judge has gone wrong, is he has effectively collapsed the approvals process into the general run of civil litigation cases that the court determines day in, day out, where the court typically proceeds, of course, on the basis that loss of privacy, even where you're a protected person, is simply the price you pay to litigate your claims. But this is simply not the right approach in an approvals case for the reasons I've outlined. Now, there are 3 points I'm keen to highlight at this stage of my submissions. First, in common with the Court of Appeal, HEDRA is not submitting that anonymity falls to be granted in every approvals case. Plainly, there may be circumstances in an individual case which militate against that outcome. We do not rule out, for example, that the balance may tip in the opposite direction in a case that's trivial on its facts, albeit in those circumstances it seems to us very unlikely that any application for anonymity would be made. But where the case is sufficiently serious that an application has been made, what we say, consistent with the Court of Appeal's judgment, is that in the ordinary run of those cases, the normal rule, as we see it, is that protected parties are entitled to keep their private settlement business private, most obviously through anonymity orders being made, as per the judgment in Dartford. That takes me to my second point, which is that as we see it, the information which the Court of Appeal was seeking to protect in Dartford was not the high-level fact that the protected person had been involved in litigation, but rather the very much more specific fact that the individual had settled their claim, as the court below itself expressly recognised in the judgment. That typically amounts to information concerning a protected person's private business. That's the language that the judge used at paragraph 125 of his judgment. We say the Court of Appeal was plainly right to conclude that protected persons ought normally to be able to keep their private settlement business private, the 2110 process notwithstanding. That links to my third point, which is that even if there has been reporting on the litigation to date, the fact of settlement will typically amount to a new development, and it is in effect in respect of that new, fresh development that anonymity is being sought, with the application for anonymity being made not in respect of the extant litigation process, but rather in respect of the discrete 2110 proceedings. And that's important because what it means is that granting anonymity in respect of the approval process should generally impact on Article 10 rights only prospectively, preventing the protected person's name being published only where it is published in connection with the settlement process, rather than unsettling any prior reporting of the litigation. So the Court of Appeal's approach does not, as we see it, give rise to the problem which may arise in other cases where the relevant privacy cap is very much out of the bag and the court is being invited to somehow put the privacy cap back in the bag, as in the case, for example, of Banerjee, the tax dispute case, which is in the Supplemental Authorities bundle, page 19. The information sought to be protected in the context of the approvals process is new information, which in the ordinary run of cases will be private and confidential, as the judge below himself concedes, unless and until it is forced out into the open through the 2110 process. And again, the judge appears not to have grappled with this fundamentally important aspect of the approvals regime anywhere in this judgment. Instead, he appears to have proceeded, paragraph 114 of the judgment, on the basis that prior publication of information concerning the litigation creates a significant obstacle to granting anonymity in respect of the approvals process, on the basis that, as the official solicitor put it, in the judge's view, the privacy ship has already sailed. But it's difficult to see why that is so when the information sought to be protected is the new, fresh, confidential, private information concerning the settlement process. As for the court's suggestion that the Court of Appeal went wrong by failing to recognise that Article 8 rights could be protected through confidentiality measures, falling short of anonymity, for example, orders that would require particular information to be dealt with confidentially, there are a number of problems with that suggestion. First, and perhaps most fundamentally, it ignores the context of the 2110 regime, including, crucially, that capacitous litigants can altogether avoid having their private settlement agreements exposed to any degree of publicity. And the fact that the settlement agreements of the protected person only comes before the court, with the court exercising its protective jurisdiction. The key point which the judge fails to address is why should a vulnerable person be put in a worse position in privacy terms than a capacitous litigant merely by virtue of their vulnerability, all the more so where the court is exercising not its civil justice jurisdiction, but a protective jurisdiction. The second problem with the court's suggestion that you should turn instead towards confidentiality measures rather than anonymity, we say that that suggestion is problematic because it ignores the crucial point that in most personal injury cases, the information with the highest public interest value is typically not the identity of the particular protected person who's been injured, but the identity of the defendant and how much money has been spent remedying the wrong. Certainly in clinical negligence cases, what matters most is which NHS body has acted negligently. That's important for detecting repeat failings, suggesting underfunding, or systematic problems within the trust. And then the next important matter in a clinical negligence case is what does it cost the taxpayer? Because it's access to that kind of information which creates the necessary transparency and accountability around our public institutions. And fundamentally, it's going to be a very rare case where the identity of the particular protected person really matters in public interest terms when it comes to the settlement process. Information as to identity may lend the story a bit of colour, but it isn't really the story. The story from a public interest perspective is the relevant NHS failings and what that's costing us as a society. And that's doubtless why in this case both media interveners did not seek to challenge the grant of anonymity, because fundamentally it's not the identity of the protected person that really matters in public interest terms. And equally it's doubtful that there'd be any public interest in naming a protected person where you're simply dealing with a run-of-the-mill RTA case. Where all this takes us is that in your ordinary run of approvals cases, concealing the terms of the settlement is likely to result in a much more serious interference with Article 10 rights than simply granting anonymity. So if the objective is to serve Article 10 public interest objectives, then the solution alighted on by the court will typically be the wrong solution. In the ordinary run of cases, it is a solution which will produce worse outcomes for Article 10 rights than the grant of anonymity. So it's essentially for those reasons that we invite you to conclude that the judge's criticisms of the judgment in Dartford are substantially, albeit not entirely, unfair and unjustified, and that the essence of the judgment in Dartford remains good law. And I've hopefully explained to the court why we say it's so important for the court to resolve the uncertainty that has been created by Mr. Justice Nicklin's judgment. And I should add that so far as we can tell from their written submissions, no party or intervener appears to be rowing against our broad position on the Dartford issue, and that includes the BBC, who's obviously intervened in this appeal. Now, I'm conscious of not taking up any more time that really needs to go to others. All I would say is that having invited you to conclude that the essence of the judgment in Dartford continues to be good law, our position is that that approach does need to be refined to some extent. I've already made the point that we say not the right approach, that protected persons are named in the cause list, because that produces illogical outcomes. But there are other proposals that we would make, a number of which are actually aimed at augmenting the protections for open justice. We've set out our proposals at paragraph 27. I'm not going to take up the court's time running through those proposals, but I do invite you to consider them, and I invite you to consider them together with the draft template order, which is at page 197 of the core bundle, which PIBA has devised so as to overcome the pitfalls in the creation of template orders that Mr. Justice Nicklin identified in the latter part of his judgment. And we would be very keen, if the court was prepared to indulge us, that you consider that draft order and whether it is a form of order that ought now in the circumstances to replace PF10. Unless the court has any further questions for me, those were my submissions. And forgive the impertinence, but assuming the court has no further questions for PIBA, might I ask that myself and Miss Reddy be released at this juncture?
Yes and yes, Ms. Proops. Thank you very much for your assistance. Ms. Greenie.
Yes. My lords, my ladies. I propose, my lord, to deal with the following matters, if that would be of assistance to the court. The first one was to make some brief observations about the derogation from open justice. I believe the court has the principles firmly in mind, but just to revisit those points, because it's my submission that the same principles apply, whether one is dealing with a withholding order or whether one is dealing with a common law power to make an RRO. Assuming
why is a withholding order different from an RRO if they're both governed by the common law?
Well, I'm saying they're the same, but in the sense it does obviously arise when one comes to section 11, when one would be simply making the withholding order with the section 11 reporting restriction order. But it's really just to say these are the principles. Obviously the court has this in mind in terms of necessity. I just wanted to highlight some points there. The second one I propose to deal with is the one of the questions raised, which is the existence and scope of the common law power to make an RRO, which in support of a withholding order and the rationale between the section 11 of the Contempt of Court Act. And my lord will have seen that I passed up the Leveller case this morning and some further extracts from the Contempt of Court Act, because as I'll come on to explain, they do appear to give some assistance as to the nature of the common law power to make a reporting restriction order and its scope prior to the coming into force of the Contempt of Court Act. I would then propose to deal with section 11 and then also go on to deal with the issue of evidence and the nature of the evidence required.
Thank you.
So starting with the principles that apply to a derogation from open justice, it's clear that justice, the common law principle of open justice comprises the fact that justice is administered in public and everything said in the court is reportable, and that's including the names. Exceptions are made by statute, or as Lord Sumption says in Cuja, where strictly necessary in the interest of justice, and that's at paragraph 14. The necessity test, and I would emphasise it's been made clear from as long ago as the Scott and Scott case that it is a high threshold. Lord Lorrebon in Scott and Scott referred to it as follows, and this is at 446 of the report, the authorities bundle at 191. I don't propose to take the court to it, but I'll read it out, where Lord Lorreban says the administration of justice would be rendered impracticable by their presence. He's talking about the public, whether because the case could not be effectively tried or the parties entitled to justice would be reasonably deterred from seeking it at the hands of the court. Viscount Haldane at 439 said the paramount object of ensuring justice is done would really be rendered doubtful of attainment if the order was not made. As you have seen, I know you've been taking in detail and looked at the A in the BBC case, both by Mr. Weir and also by Mr. Brown. That it said there, obviously the category, it's made clear, the categories are not closed, but strict necessity must be established. And there are various different situations that are discussed there. And as has been ventilated before the court, it said the court can take steps to ensure the interests of justice are not defeated in the future. That was with reference to the undercover police officers giving evidence and to avoid them, not being able to carry out their functions in the future. You've also been taken on a number of occasions to where the principles are set out in A and BBC at paragraph 41, where I'll just turn that up now.
Page 615.
Yes, 615, please. And it's the final sentence commencing central to the court's evaluation will be the purpose of the open justice principle, the potential value of the information in question in advancing that purpose, and conversely, any risk of harm which its disclosure may cause to the maintenance of an effective judicial process or to the legitimate interests of others. So that the Lord Reid there is capturing the two aspects of it, the maintenance of the effective judicial process or to the legitimate interests of others. And indeed, examples given by Lord Reid in those preceding paragraphs, 38 to 40, comprise both sorts of situation, some which appear more focused on the legitimate interests of others, or there may be a combination. Perhaps one example to look at is paragraph 39, and it's at G, where the example given is the HM Advocate and M case, where a Section 11 order was made to prevent the publication of a woman who was the principal witness at a trial for having been recklessly infected with HIV. So there was evidence before the court that her mental health would be endangered if her identity became known, exactly say her interest. But there was also a risk that she would otherwise be unable to give evidence, in which event the prosecution could not proceed, and that aspect obviously more centrally falls within the maintenance of an effective judicial process. So, I mean, I agree entirely with the comments that have been made previously. All these cases turn on their own facts. They all give rise to unique issues. But as has been said in Cuja, the necessity is the touchstone of the jurisdiction. And I don't understand there to be any dispute that there must be some evidence that in order to derogate from open justice and to establish necessity, some evidence must be adduced. And I would say that's been made clear as long ago as the Scott and Scott case, and that's by Count Haldane at 438.
Is that 438 in the authorities bundle?
It is. No, when I'm going to give you now, it's at 183 of the authorities bundle, and it's the second paragraph, starting, I think that, and it's the passage starting 8 lines down, but unless it be strictly necessary for the attainment of justice, there can be no power in the court. And he continues, the next sentence, he who maintains that by no other means than by such a hearing can justice be done may apply for an unusual procedure, but he must make out his case strictly and bring it up to the standard which the underlying principle requires. So that's a very old statement of the principle. In more recent cases, it's been described as the need for clear and cogent evidence, and you see that as being recorded as the test in paragraph 13 of the Interim Orders Practice Guidance, which is in the Authorities Bundle at 124. And earlier today, my lord, you were formulating a test as to the derogation from open justice for the purposes of administering justice, to do justice, and said that is the test the purpose the purpose being to protect the integrity of the court process, to avoid the frustration of court orders, and in my respectful submission, that appears to be correct in terms of a necessity. The court is acting when derogating from open justice. The court needs to be satisfied that it is acting so as to protect the integrity of the process or avoid frustration of orders, etc. But I would also
where do
agree.
those words come from most clearly?
Certainly the passages that I have cited to you from Scott and Scott and Lord Lorredan, where I said the 191 of the Authorities Bundle, the administration of justice would be rendered impracticable by the presence of the public, whether because the case could not be effectively tried or the parties would be reasonably deterred from seeking it at the hands of the court. It's obviously reiterated in A in the BBC by Lord Reid in various passages, where he says necessary in the interests of justice at various passages, for example 38.
Yeah, it seems to be all over that case.
Yes, I mean it's repeated, it's put in slightly different places. I'd say that certainly that's
18 and 48.
yes. So I would now move on. I'm now proposing to move on to the question of the existence or the scope of a common law power to make a reporting restriction order in support of a withholding order and the rationale behind the Contempt of Court Act. Now, you were taken to some of these materials by Mr. Weir yesterday, and including the statement in A in the BBC at 6:20, paragraph 59, where there was a discussion about, Lord Reid was discussing section 11, and at 6:20, just above letter G, the purpose of section 11 is to support the exercise of such a power, namely a withholding power, by giving the court a statutory power to give ancillary directions prohibiting the publication in connection with the proceedings of the name or matter which has been withheld from the public in the proceedings themselves. Section 11 thus resolves the doubt which had arisen following the socialist worker case as to the power of the court to make such ancillary orders at common law. You were taken also in the additional materials sent by the court. There is the Law Commission Contempt of Court report, which is Authorities Bundle 1488. Actually, I recall yesterday that I'm not sure that you have this in a paginated.
Yes,
form.
I do actually.
My pagination is different. I've got it as a separate.
Yes, it's
if you give me the internal
paragraph.
number.
Yes, it's paragraph A119, internal pagination 29, over to 30.
Sorry, we're going to have to say that again. 8.
It's in the Authorities Bundle 1488.
A119.
A119, and then over the page to A120, which is a reference, as you'll see, to the socialist worker case, and the recommendation that the court should be empowered to forbid the publication of names of facts of this kind. And then it goes on to describe the green paper and the Phillimore discussion. The green paper devoted more attention to the question, particularly the trial within a trial and confidential details, such as the name of blackmail male victims, and agreed with the recommendation added in the footnote that there should be a judicial power to forbid the publication of these details. So I'm going to go briefly to the socialist worker case, which is in the Additional Authorities Bundle at 1294. It's the first, it's 5.1, tab 5.1. As can be seen from the footnote, it was during the trial of a defendant for offences of blackmail. The judge directed the two victims of the alleged blackmail should be referred to as Ms. Y and Mr. Z. They gave evidence before the end of the trial. An article appeared in a newspaper which purported to give their names, addresses and certain particulars of the victims. And you can see from what was held was that in publishing the names of the victims in defiance of the judge's direction, they were committing an affront to the court's authority to protect witnesses from victimisation, because they had given evidence before the court and were in contempt of court. What can be seen from the Chief Justice's judgment, and this is at 650, so 1307 of the Authorities Bundle, letters B to C. And it can be said there that the submission made to the court, he said that the order made by the trial judge in this case, you have that, it's just below the letter B, did not extend to ordering the press not to disclose the two names of the witnesses. And the Chief Justice said, that I think is absolutely correct, and my reading of the judge's direction is that he was directing what was to happen in his court, and was not in express terms dealing with anything which was to happen outside. But what can be seen nevertheless was that whilst the direction was not directed at those outside court, nevertheless the two the journalists were found in contempt, and the grounds for that you find on page 1309, just above letter G. Again, the Chief Justice saying, I feel bound to say that it has, for the reasons which I've already given, and on both grounds, the finding of contempt, is an affront to the authority of the court following the Butterworth case, and secondly on the ground that by destroying the confidence of witnesses in potential future blackmail, there was an act calculated to interfere with the due course of justice. So as is seen from the Law Commission report, there was said to be doubt as to the power of the court itself to make reporting restriction orders following this case. And there is further discussion, and this is in the additional authority that I sent to the court this morning, the case of the Attorney General and Leveller decision of the House of Lords. And here, this was a case, just just looking at the head notes, so if the court has that, obviously this is a separate document, I'm afraid, but so the committal proceedings related to 3 defendants charged with offences on the Official Secrets Act. So a prosecution witness so an application had been made for that witness to be referred to as Colonel B, and for his name to be written down and shown only to the court, the defendants and their counsel. And then what happened was, during cross-examination, Colonel B himself actually gave his official name and number of the army unit to which he belonged, and stated that his posting was recorded in a particular service magazine, which was publicly available. And his name was subsequently published in 3 magazines. And that's when the Attorney General brought proceedings to commit. And then you can see at the bottom of H, but before the motion came on for hearing, an affidavit by the clerk to the magistrate was filed in which the clerk denied that any explicit direction had been given, namely a non-publication direction, for the reason that he advised the magistrate.
So where are you reading?
Sorry, I'm near H on the first page.
Okay.
Sorry. And I should probably have said it was alleged the magistrates had expressly directed that no attempt should be made to disclose his identity. But you'll see below the clerk denied having given any explicit direction. And hence the motion proceeded on the basis that no explicit direction had been given. So there was a discussion of on the facts, it was found that given what had happened in the way in which the colonel had given evidence, the intended effect, as it were, had been abandoned. I'm looking now below between B and C, such that there was no finding of contempt because this evidence had been given without protest by the court or the prosecution, such that his name could readily be deduced. But what there was discussion of in the judgments was this question as to whether the court had power, and you can see this under towards just above letter F, whether a court has power to make such a ruling ipso jure binding on persons outside the courtroom. And
probably convenient to start with what the ruling was. A D, because the majority affirmed the right of the magistrates to make a withholding order in
Yes.
respect of the colonel's identity, and the next stage was the question of whether they could make an
Yes.
order enforcing that against all the world.
yes, exactly. And yes, I'm grateful, my lord. So they were saying that was an accepted extension of the power to conceal his identity, extension of the court to control its own proceedings. Quite right, and that's those 3. The majority found effectively the greater included the lesser. So the power to sit in private included the lesser power to withhold his identity. And then they did go on to say, to consider this question, whether there was a power at common law to make such an order, as it were, binding on the world. And then you find this, again in the head note, it cited Lord Edmund Davies. A court has no power to pronounce to the public at large such a prohibition against publication, but all disobedience to it would automatically constitute a contempt. Lord Diplock...
Was he dissenting?
No.
No. Lord Diplock said it was an open question. And
Where's
you
that?
find that at 451H. So he did not express a view on it. The others did express a view, and that's Viscount
Dillon.
Sorry. I'm sorry. At 456 B to D.
456.
6 B to D. Particularly C to D. I leave you to read that.
says there's no statutory provision.
Yes. Okay, so as there is no statutory provision which gives to a court power to make an order applying to all members of the public prohibiting the publication of information, which might lead to the identification of such a witness, it follows, in my opinion, the advice was right. And if the chairman had given any such direction, it would not have operated to convert conduct which otherwise did not constitute a contempt into one. So in the absence of a statutory provision, there was no such power. Lord Edmund Davies considered this in some more detail at starting at 463E, where he started by looking at the socialist worker case. And then his conclusion on this is, if you go over to 464, 4 lines down, halfway in, in the 4th line, after considerable reflection, I have come to the conclusion that a court has no power to pronounce to the public at large such a prohibition against publication, that all disobedience to it would automatically constitute a contempt. But goes on to say it is beyond doubt that a court has a wide inherent jurisdiction to control its own procedure. In certain circumstances, it may decide to sit wholly or in part in camera. And then further down that paragraph by letter C, he says, or the court may direct that throughout the hearing in open court, certain witnesses are to be referred to by letter or number only. But it does not follow that were a person, and even one with knowledge of the procedure which had been adopted, thereafter to make public that which had been wholly or partially concealed, he would be ipso facto guilty of contempt. He goes on, continues, and then there's some further over on to page 465 by B, letter B, and what appears certain is that at common law, the fact that a court sat wholly or partly in camera, and even where in such circumstances the court gave a direction prohibiting publication of information relating to what had been said or done behind closed doors, did not of itself in every case necessarily mean that publication thereafter constituted contempt of court. And goes on to say, for that to arise, something more than disobedience of the court's direction needs to be established. That something more is that publication must be of such a nature so as to threaten the administration of justice, either in the particular case in relation to which the prohibition was pronounced, or in relation to cases which may be brought in the future. And he says it relies on all the circumstances. And then Lord Scarman also gave a view on this at 471H. You can see it under the heading Contempt of Court, the third question. End of the second line there. Can a court make an order or give a ruling which is binding on persons who are neither witnesses nor parties in the proceedings before the court? It is a misconception of the nature of the criminal offence of contempt to regard it as being an offence because it is a breach of a binding order. The offence is, going on to the next page, the offence is interference with knowledge of the court's proceedings with the course of administration of justice. It was for this reason, no doubt, that Lord Widgery, Chief Justice in this case, stressed the element of flouting the authority of the court. Though I would not have chosen the word, I think it does reflect the essence of the offence, namely the conduct complained of, in this case the publication, must be a deliberate frustration of the effort of the court to protect justice from interference.
But all that is about the contempt aspect.
Yes, well, it's
rather than the jurisdiction aspect.
It is, my lord, but it's really to say that what I take from this case, because this is obviously the coming into force of Section 11, is that the court had power, certainly to bind the parties before it, application reporting restriction order, and third parties who are not directly bound by it could be in contempt if they, coming to know of it, act deliberately to frustrate its purpose. But what, hence the question arises, what difference does section 11 make? And that would, what that appears to have done, in my submission, by putting it on statutory form in the context of the Contempt of Court Act, is enable, because it's on a statutory basis, orders to be made, reporting restriction orders, that are directly binding on the world and which have as their effect, obviously under the Contempt Act, the strict liability rule under section 1, this is why I passed this up to the court, the rule of law whereby contempt may be treated as contempt tending to interfere with the course of justice, regardless of intent to do so. That would appear to have been the effect of the statutory provision, that it was brought within the Contempt of Court Act, and contrary to the position where the House of Lords in Leveller was saying third parties are not directly bound, they're not automatically bound by the order itself, but they can nevertheless commit contempt if they know of the order and act deliberately to flout it. Section 1 and the Contempt of Court Act appears to have put it on a different basis, such that third parties are directly bound. You can have contramundum injunctions that bind the world under section 11 with the impact of the strict liability rule, obviously subject to the defences in the Contempt of Court Act.
So are you saying something different from what Mr. Ware, Mr. Hyam and others have, maybe others, have said earlier, which is that there is a common law jurisdiction to derogate from the open justice principle by making both withholding orders, I forget which one is which, I'm afraid, because it's so totally illogical, but by making withholding orders, anonymity orders and reporting restriction orders, the two being encompassing one of them, do you say that there was no common law jurisdiction before section 11 to derogate in that way and make an order which bound third parties?
Certainly that directly bound a third party in the sense of being a contramundum order. And I was going to now to take you to some passages in Wolverhampton that I think assist with this. A contramundum reporting restriction order binding the world so that third parties were directly bound by the face of the order. But there was a common law power to impose a reporting restriction order on those who were parties to the proceedings, and the legal effect of that was if a third party, such as a member of the press, found out about that order and then deliberately published something with the intent of interfering with the court's administration of justice, they could find themselves in contempt. But that it's now clear, I would say, following section 11, that there is a statutory basis.
But I mean, just a minute, sorry. These are not cases where anybody applied for an order binding the world not to publish information going on in court. These are cases where something went on in court and the judge said, we will refer to Mr. Smith as Mr. S. Yeah. And they went on and referred to him as Mr. S, and then the socialist worker came along and published Mr. S's name, having established it, and the question was whether they were in contempt. But the authorities, the more modern authorities, take a much more holistic view of the law and look backwards and forwards and seem to me to say that there always has been, even if not recognised interest in the facts of the leveller or the socialist worker, there really has been a common law power. First of all, the principle of open justice is a common law principle, and the ability to derogate from it is a common law jurisdiction, is a common law power that exists in the court if it wishes to make an order to that effect. Different from an equitable injunction granted under Section 37 now, which is an equitable jurisdiction to grant injunctions against the world, approved finally in Wolverhampton. Now, what I'm concerned to know is, do you say that that power did not exist in the time of the leveller? Because if so, and then that would indicate the only power, real power, jurisdiction, to make the order that is sought in this case is in Section 11, which is not, I think, what Mr. Ware and Mr. Hyam are asking us to hold.
No, when you say, my lord, the power did not exist, you mean do the equitable jurisdiction?
No, I don't. I mean, this is the whole point, and it's all the confusion. There are three potential jurisdictions. Common law, good old common law, going back since time immemorial. There is, secondly, the equitable jurisdiction to grant an injunction in equity. See Spry on injunctions or etc., books like that, which has existed. I mean, there's a marvellous history of it in a case called Convoy Collateral in the Privy Council. And then, and in Wolverhampton, I'm sure. And then there is a statutory jurisdiction. Now, I use the word jurisdiction, but everybody objects to that because they say that includes the exercise of the jurisdiction. I don't personally think so. I think jurisdiction means the power, but it doesn't matter. Three powers: common law, equitable, and statutory. Now, here it is said that there is a statutory power in Section 11, but it's also said there is an equitable power, which we know what Lord Reed thinks about exercising that if you don't need to. But my concern is to be sure what you say
Yes.
about whether there was a common law power to derogate from the principle of open justice. I'm very pleased you've taken us to the leveller because it seems to imply there isn't.
Well, my interpretation of it, my lord, and I was going to take you next to the textbook, one of the textbooks, the David Rolfe textbook, which I think insists on this as well, is that there was a common law power to derogate from open justice and to make a reporting restriction order that bound the parties to the proceedings. What I take from leveller and what their lordships say, that did not include the power, as it were, to make a contra mundum reporting restriction order that directly binds third parties. But the court,
if so, it was totally ineffective.
well, no, because in the sense of what they were saying was, and what happened in these cases was that members of the press who knew the order made directed against the parties could find themselves in contempt if they acted deliberately. There was a need for a motive. They
No,
had
I
to
understand, but I mean, if they didn't.
I mean, it sounds, but that's what I take from that case, and that's what I understand. I mean, the position of common law was said to be unclear. I mean, hence the, as you see, the Law Commission recommendation for putting on a statutory footing the power to bind the world and make the reporting restriction orders, because if I tell you maybe a convenient point to go to the David Rolfe book.
Well, I mean, I'm very happy for you to go there, but I'd love to go to Wolverhampton first.
Yes,
David
of course.
Rolfe is very interesting, but
I mean,
I find textbooks deeply unhelpful.
I mean,
if there's
he's
law.
more, and he is actually talking about a lot of Australian authorities. But in essence, I can summarise it. He's saying it is unclear. There was an Australian authority that said the court has a common law power to make reporting restriction orders that bind the world. But it also said there were other authorities, such as Leveller, that said that that was not the case.
It's relatively recently in our legal history that orders against the world have been a feature of the litigation landscape, and probably at the time of the leveller, they were at least uncommon, if not exceptional. So things have developed, haven't they?
I would accept that.
What the Lordships are talking about in this case is the difference between making orders against people who are in front of you in a piece of litigation and people who have no notice of what you're going to do and are then going to be bound at risk of being in contempt of court if they contravene the order that you've made. And that's quite a big step. We don't regard it as an impossible step anymore.
Yes. I mean, if I start, you would take, if I go to Wolverhampton now, and you were taken this morning by Mr. Hyam to paragraph 155, which is at 1135. And particularly the passage about halfway down by letter D.
Sorry, 155.
1135, sorry.
No, but which para?
155, sorry.
Yes.
Yes. And actually, just picking up between C and D, it says very occasionally courts have already been made, orders have already been made in something approaching a contramundum form, as in the Venables case already mentioned. More frequently, the court has expressly recognised after full argument that an injunction against named persons may involve third parties in contempt for conduct in breach of it, where, for example, that conduct amounts to a contemptuous abuse of the court's process or frustrates the outcome which the court is seeking to achieve. Referring back to Bloomsbury and then Attorney General's newspapers. And goes on to say, discussed at paragraphs 37 to 41. It was those paragraphs that I wanted to take you to.
What, in Attorney General? Oh, I see that.
No, in Wolverhampton, actually.
37 to 41.
Yes, which is on 1101. And this is 37 is explaining the point that my lord was referring to about how non-parties may be bound by an order, obviously, if they know of it,
Yes.
and held in contempt. And then going over the page to paragraph 41 and then 42, we can see here what's said is there's accordingly a distinction legal principle between being bound by an injunction as a party to the action and therefore being in contempt of court for disobeying it, and being in contempt as a non-party who by knowingly acting contrary to the order subverts the court's purpose and thereby interferes with the administration of justice. It does say, nevertheless, cases such as Attorney General and Times, Attorney General and Punch, and the daily impact of freezing injunctions on non-party financial institutions indicate that differences in the legal analysis can be of limited practical significance. Since non-parties can be found in contempt of court for acting contrary to an injunction, it has been recognised that it can be appropriate to refer to non-parties in an injunction in order to indicate the breadth of its binding effect. And then it says, prior to the developments discussed below, it can therefore be seen that while the courts have generally affirmed a position that only parties to an action were bound by an injunction, a number of exceptions to that principle has been recognised. Some of the examples given also demonstrate the court can, in appropriate circumstances, make orders which prohibit the world at large from behaving in a specified manner, which obviously are a reference to the contramundum. So it looks like the court here is just drawing this distinction between different types of injunction, both which can bind third parties, but in different ways. Namely, they can be found in contempt for disobeying an injunction, even if they're not bound, if they're a non-party, but they knowingly act contrary to it. Or you can have actually the contramundum orders, which prohibit the world at large.
Well, you see, I mean, what troubles me is paragraph 34, which without reference to all those other paragraphs that talk about the legal history, say reporting restrictions are prohibitions on the publication of information about court proceedings directed at the world at large. They are not injunctions in the same sense as the orders which are our primary concern, but they're relevant as further examples of orders granted by courts restraining conduct by the world at large. Such orders may be made under common law powers or may have a statutory basis.
Yes, I mean, I agree, my lord. I think it is very difficult, but what struck me about this paragraph, as I read it again, having read the other cases, is it does go on to say a person will commit a contempt of court if, knowing of the order, he frustrates its purpose by publishing the information in question. And then the references is to the Leveller case, which obviously we've just looked at, and Re-F, which actually is one of the, I hadn't actually highlighted it, but when you go back to look at the Leveller case, that's one of the cases that Lord Scarman is talking about namely a third party who's not directly bound, but finds themselves they are in contempt if they knowingly act contrary to the order. So I think it's unclear. I'm not suggesting at all I can fully explain what the Supreme Court has in mind here, but there does appear to be reference both to what could be contra mundum injunctions, but also this other type of reporting restriction order, that binds parties to proceedings and can then have third parties can find themselves in contempt of it. And then the only other reference point that I wanted to, or paragraph I wanted to go to in Wolverhampton is 31, simply to distinguish the language that is used here when talking about the wardship cases, which is on 1099, and that is the reference to the Exeter minor, that's the Mary Bell case, which you'll recall I dealt with in my submissions, where how that is described, the nature of that order, is if you pick it up, the line below H, the order bound everyone, whether a party to the proceedings or not. In other words, it was an order contra mundum. Similar orders have been made in subsequent cases. So that is expressly there by the Supreme Court being described as a contra mundum injunction. Obviously, the language in 34, it does talk about directed at the word at large, restraining conduct by the word at large. So it's difficult to say that that's not talking about contra mundum injunctions, but it would appear from that final sentence that this may also be, in the sense of the common law powers, a reference to what is being described in the Leveller case.
An order is directed at the parties, but has an effect on the parties if they know about it and act in such ways to frustrate its apparent purposes.
Yes.
It's not very easy to reconcile that with the language used, on the other hand.
It's not at all.
The cases don't support the proposition.
No, I don't think it is at all. And having looked further into the following the very helpful authorities and materials sent by the court, it seemed to me important to bring the Leveller case to your attention. But I think it does show there was a common law power, but there's this. The question really is what is it affect? I agree. It's in terms of the law of contempt and how third parties find themselves in contempt of such orders.
Can I try something on you, which may be the wrong thing, but I'm just trying to work this through. Is it something, in a sense, if you have an order, whatever your jurisdiction to make it, that says you can't publish this detail, that's always going, in a sense, to be contra mundum, because that's everybody's bound by that. Nobody can publish that detail. But what the common law is getting at is making that sort of order because you need to preserve the integrity of the process, the very litigation process that you've embarked on. So the reason why you're making it is a sort of internal-facing reason. It's to do with the parties, it's to do with securing fairness, interests of justice, that sort of thing. When you look at the other sorts of orders that we've looked at, albeit in a more modern context, they're orders that are after the litigation has finished.
Yes.
They've got, it's not to do with preserving the integrity of the process at all. And maybe it's our language talking about using contramundum to describe one sort and not the other sort, because actually what you're doing in both cases is the same sort of thing. The mechanic is the same, but your reason for doing it is completely different, and that may be where you lead to different jurisdiction.
Yes, I certainly agree with that in terms of what is the difference between the common law jurisdiction, which is certainly based on the control of the proceedings before the court and managing the proceedings and ensuring the administration of justice, and the separate jurisdiction, as you say, whether we call it Venables, equitable jurisdiction, which is much broader. You can say it can
It's a much
be
bigger, it's an injunctive, it's a much bigger piece of work, isn't it?
It is, and as we've seen from the many cases, that it can be brought, after proceedings have ended, it can be brought, as it was in Ries, for an injunction made in the family division to impact on reporting in another court, in the criminal court. So it is, yes, it is much broader, and I agree it is a different jurisdiction.
Aimed at a different purpose, it's got a different momentum to it.
Yes. But the effect of this, and what I took from those passages in Wolverhampton was they were saying anyway, however you get there, even if it is this narrower, the impact on it is narrow in the sense it doesn't directly bind third parties. They can be found to be in contempt of it. So it has this effect anyway. Third parties can't ignore it. They can't act contrary to it. So it may be dancing on a head of a pin.
Exactly. It's all
With
different
all
ways.
it's so technical.
Yeah.
But
Well, I'm not sure it is dancing on the head of a pin, because the orders we're being asked to make here are orders that expressly prevent publication. And preventing publication has to be taken very seriously by the press. Of course, it's unfortunate we have no press representation here today, but we had it yesterday. This is a significant question. It's not just, is the order going to get the press into trouble if they disobey it? It's, does the order bind the press?
yes,
And I've been looking in Abassi to see where Wolverhampton is explained, and it does seem, doesn't it, that in the language of paragraph 51 of Abassi, talking about contramundum injunctions, says such injunctions are wider in scope than reporting restriction orders as ordinarily understood, which restrict the reporting of court proceedings, for example, by prohibiting the publication of the name of a witness. They're also different in that they are usually made in proceedings held in private. In other words, unlike reporting restrictions orders, they don't necessarily make inroads on the open justice principle. For all these reasons, to be confusing and potentially misleading to describe these injunctions as reporting restriction orders. Well, let us take that stricture to heart and not do so in future. And he then goes on to consider parens patriae jurisdiction and contramundum orders, Broadmoor jurisdiction 69, and then comes to the clinician's cause of action in tort. And obviously none of that is what we're dealing with. Then we get to the inherent equitable jurisdiction and Section 6 of the Human Rights Act, which is taken alongside Section 37. And I can't think that he goes back to reporting restrictions. I don't think he does he?
Paragraph 115 is mentioned.
119.
115.
115, that's right, you mentioned it.
Page 1261.
yes, that's the oath of justice discussion.
So 115 then. So there's an assumption there that there are such things as reporting restriction orders, which appear to be something you do at common law. And there's nowhere explained in any of this how you went from injunctions, a situation where injunctions could not be granted to prevent reporting against third parties in the leveller, to there being no jurisdiction to grant such injunctions in Cuja, well, and in the Privy Council in independent reporting or whatever it's called, to there being that kind of more general jurisdiction beyond the parties, the purpose of which is obviously simply to protect the integrity of the proceedings. So at some stage there seems to have been an assumption that modern life, I mean really what my Lord was referring to a moment ago, modern life, which has brought us, and this is I think important, it's brought us freezing injunctions being regularly granted in the court, which affect incrementally over many years third parties and are served on third parties, refer to third parties, say you the bank must not do this, and their orders contra banks, even if not contra mundem, since all of us are not banks, and also orders against the press, the world being the press, in the Venables type case, which have become more and more common recently. And then we have Wolverhampton with the gypsy cases, which again are more and more common, persons unknown, and see, earlier judgments actually in Wolverhampton, which actually deal with that jurisdiction in itself, which goes back a long way as well. So without taking all those things into consideration, you don't quite know whether what we put to the court this morning, namely that there is a common law jurisdiction, well-established jurisdiction to derogate from the open justice principle and make orders against the world, giving effect to that derogation, is right. And indeed, it seems possibly to me that it's not right, and that the only order you can make is not against the world, but in which case, where does that leave the Morava jurisdiction, and why is that not okay?
Yes, I mean,
There was a reference in the passages you were showing us earlier to before the developments we referred to before.
yes, yeah.
And I was wondering at the time what those developments were, because they weren't identified, but I think they were such matters as persons unknown injunctions, which was what was in fact in issue in Wolverhampton.
Exactly.
It certainly included that.
Development.
I gave two judgments about this, one in the persons unknown case, a long historical analysis of persons unknown injunctions, and another in one of the contra mundum cases, where there was some, I can't remember the names of the children, but there were terrible murders, and I granted a contra mundum injunction. And the history goes back of the contra mundum goes back to, I think, Dame Elizabeth Butler Sloss's first decision before Mary Bell, or maybe the first one was Mary Bell, I can't remember. Mary Bell was the first one. But anyway, so we're talking about the 60s. So this was all going on at the same time or before Leveller. Leveller takes ploughs one furrow. Cuja and the criminal courts plough another furrow. Persons unknown plough an entirely separate furrow. Morava injunctions go back 50 years because we had a celebration a few weeks ago of that 50 years. They go back 50 years, but obviously they didn't start to be against the world until much later than 50 years ago. So we do have to put all this end to end. We have to put this together, or there's not going to be coherence, right? Is that right?
Yeah. Yes, I agree, my lord. That's certainly the case in terms of dealing with the common law power. I mean, what has struck me, having considered this further, is where does that leave? Obviously, the breadth of the court's power to make a withholding order, again, which is exercised in accordance with the principles for derogating from open justice. What is the breadth of that power such that it can be combined then with a Section 11 power? Which obviously comes back to the question, was the learned judge wrong below when he said that had to be made at the outset of the proceedings? Because it certainly seems to me that, having looked at what is said in the BBC about the power to derogate from open justice, and those passages, I mean, I was certainly inclined to agree with Mr. Brown from the BBC. They are focused on withholding orders, but leaving that question aside, whether they're also dealing with the common law power.
Sorry, just remind me, you use the term withholding order to mean just anonymisation.
Just anonymisation, so the precursor to the Section 11 power, the withholding order. And Mr. Weir took you through the trio of cases and explained the limitations of them. I had set those out in my submissions. There is that passage for the Chief Justice, Lord Judge, but I think it's, as I said in my submissions, important to note that actually is overture, because the Section 11 jurisdiction hadn't even been used in that case in repress association. Erroneously, the judge had used Section 4.2 and then also used the Sexual Offences Act in respect of the defendant of the proceedings as opposed to a victim. But looking at it, when one accepts that the principles for derogating from open justice, it's the same approach to be adopted, whether one's talking purely about the withholding power or any common law power to impose a reporting restriction order. Why should the withholding power be so limited? Why can that not be sufficiently expansive that the court can withhold the name in order to do justice, in order to ensure that to control its procedures, to ensure there is not, it is not impeded in doing justice in the case of...
And in the modern world, even if there was an artificial limitation before, in the modern world with the internet and with AI and with lists for the court being published all over the world to anybody who ever wants to see them for all time.
Yes.
Because we used to think open justice involved putting the name of the defendant, Crown against Smith, on the door of a little court in Putney and taking it down at 4:30, and that was the end of that. Nobody could ever see it again. Well, if you were the hapless Mr. Smith, you would hope people didn't walk into the court in Putney at 10:30 on a Tuesday, but came on Wednesday, by which time it would be the Crown against Mr. Jones. But the point I'm making is open justice now is completely different. That list is available forever and a day, including the name of Mr. Smith.
Yes.
And I'm just very concerned that we do take into account the real world.
Yes, quite, my lord, and hence the concerns which you've rightly heard from the official solicitor and others, that if there is this very sharp cut-off point, if a claim form's been issued or something's in the public, there's some publication of the name in connection with the proceedings, effectively, that's...
Well, I mean, you say Section 11 simply doesn't say that anywhere.
No, I agree with Mr. Weir, it doesn't say that, and it seems to me, if one's looking at it, it depends upon the court exercising its existing power to make a withholding order. That power must be exercised, the court must be satisfied it's necessary to derogate from open justice to protect its process. And that of itself, in my submission, it can properly be said that doesn't arise only at the start of the proceedings, but it's obviously a fact-sensitive question whether the court considers it is necessary, and there may be cases where plainly matters of there's so much in the public domain or matters have gone so far, the court might reach the view it's not necessary. It might say if I, the judge, were to withhold the name at this point, it would call the administration of justice into disrepute, because it would be a nonsense, because so much is in the public domain about this individual.
I mean, Section 11, the terms of Section 11, having done this fantastic tour of the authorities, the actual terms of Section 11 are rather interesting.
Yes.
Because the question is whether they reflect the common law or what people would have liked the common law to be, but they allow a name to be withheld from the public in proceedings before the court. Well, that's probably no more than anonymisation, or potentially no more than anonymisation. In a case where a court allows that to happen, a court may give, and that's in the proceedings, the court may give such directions prohibiting the publication of that name or matter in connection with the proceedings as appear to the court to be necessary, blah, and that is a prohibition on the world at large.
Yes, I agree. That's what it achieves.
I mean, my lord has emphasised for the purpose of, in connection with the proceedings, prohibition in connection with the proceedings, but that doesn't narrow it to being not against the world at large. So if that reflected the common law, or what some people thought the common law was, it's much, much broader than leveller.
Yes. That's right. But of course it was said, as the Law Commission said, that it was acknowledged that there was doubt following certainly the socialist worker case, and as expressed, a leveller followed on from that, as to the court's power at all to make such an order, and hence Section 11.
There was no doubt about the court's power to withhold information from the public where that was necessary.
Yes.
Everyone agreed about that, and the leveller affirmed that, approving of what had been said in Socialist Worker, so that was clear. The only doubt was about the existence of a power to go further and prohibit everyone from publishing that information. It wasn't necessary to decide that question in any of these authorities, because they were all about contempt, and the court universally took the view that contempt could be meted out without the need to establish that an order had been made or even could be made. So all of this stuff was over.
Yes, well...
and that's why there was doubt, which was put to bed by Section 11 being enacted, not resolving whether the common law said one thing or the other, because the common law was not repealed or abolished by virtue of Section 11, it's supplemented, whatever it was. I think that's how I understand the position. Mr. Weir is nodding, which is encouraging.
Yes, I don't understand, as it were, the common law power as it existed to have been removed by Section 11.
No.
It still exists. And really, the reason for bringing the leveller case to attention was to look at what was the scope of it before.
Yeah.
Another point, my lord, that had struck me about the wording of Section 11 is also the last phrase, for the purpose for which it was so withheld. I mean, that's also broad. The court determines the purpose. I mean, it says prohibiting the public may give such directions in connection with the proceedings, but it's not even to the extent we say the common law power was limited to ensuring the effective administration of justice. I mean, it hasn't even been narrowed to that extent.
Well,
power, but
except purpose which it's withheld is just withholding the name from the public. And so it is quite narrow. I mean, it's not super helpful as a provision, but it is what it is. Yeah. Okay. Well, I mean, I think I don't think you very helpfully made the problem more difficult.
No, I'm sorry. I was just the one final point that had occurred to me as a question that I was asking was, in terms of this, the looking at the power derogate from open justice and asking the question, where is the line? Are there limits as to the power? It seemed to me that the Banerjee case that was in the additional bundle certainly provided some, as it were, practical guidance as to the circumstances in which the court may decide, particularly where it's asked to make a reporting restriction order, or if I call it an anonymity order, namely the whole thing, at a later stage of the proceedings, where Mr. Justice Henderson, and I'll just call this up, is saying, sorry, I'm just finding the reference for you.
It's at page
131.
19 in, oh sorry,
Yes,
not 19,
it's on the final page.
1311.
1311. Where, sorry, I'm being very slow. Yes, and it's on the final page of the judgment, where of course you'll recall that the court said here they wouldn't have actually withheld this individual's or name even at the start of the case because of the importance, in a tax case of an individual being named, and he wasn't satisfied by the case that was put forward. But it was at the top of this page, the discussion at 467, starting the first line, the preponderance of English authority supports the view that once material has been read or referred to in open court, it enters the public domain. And I was saying there's a need for a clear and simple rule on this point, which reflects the principle of open justice, which could be overridden, if at all, only in exceptional circumstances. And then continues. And then it's the second paragraph, 39. The court should never make orders which it cannot police, or which are liable to cause confusion, or which may bring the administration of justice into disrepute. And went on to say that in that particular circumstance, actually that was a case where the whole case had been heard in public. The application to be anonymised was made only at the point when the judgment came out. It was made more complicated by the fact that there was a separate pleading, which was not redacted, and so that you would have an anonymised judgment sitting along an unredacted case stated, and the judge said that would clearly be absurd. And then went to say, what would the law reporters do? What are they allowed to report? And I really that's obviously a particular factual situation, but it seems to me it does illustrate the sort of circumstances where a court later on being asked to make an anonymity order when there is either lots of material from the proceedings themselves, for example, say there has been a fully reported judgment on liability which sets out the claimant's name, or indeed there's a lot of material generally in the public domain about the individual, how a court might reach the view it's not necessary and would actually be contrary to the administration of justice to make an order, because members of the public could, as it were, lose confidence in the process of justice if the court went around anonymising people when there was so much information otherwise about them in the public domain. I'm not sure if that helps, but it's just...
when did Part 39.1? 2019, was it? Because Rule 39.1, sorry, Rule 39 3 says a hearing or any part of it must be held in private if and only to the extent that the court is satisfied one or more of the matters set out in subparagraphs A and G, and that it's necessary to sit in private to secure the proper administration of justice, and that those words are repeated then in the identity of any person shall not be disclosed if and only if it considers non-disclosure necessary to secure the proper administration of justice. Now the judge in this case said that that gave no power, was no power, jurisdiction by itself to do any of that. Never quite understood why. Because it's a statutory instrument, isn't it? It's made by a statutory instrument.
It is. I mean, I did, in my submission, I did draw your attention to a case which was saying that it's the civil procedure rules, as it were, don't expand the common law position. You know, they don't go further than the actual common law.
Why not?
I don't think the case really said. I'm sure it wasn't into why.
Because of the terms of the Civil Procedure Act. Well,
oh, the civil, exactly.
Civil Procedure Rules come from the Civil Procedure Act. The Civil Procedure Act says it will give you matters of procedure.
Section
The
6?
issue-
Section 6?
Section 1, I think, of the Civil
Section 1,
Procedure Act, and it's the issue is then, are you dealing with a substantive law issue which cannot be changed? And there's guidance on this, as I said in my submissions yesterday. There's a very interesting judgment called General Mediterranean against Patel in 2000 from Mr. Justice Toulson in relation to the law of confidentiality and a wasted costs provision in the Civil Procedure Rules, which he struck out.
It's not
There's on
section.
Travaris.
Yes, my lord.
It's not section 1.
Well worth the read. I'm sorry, I haven't brought a copy. But it's in a weekly law reports.
It's not section 1. Section 1 just says there should be rules.
Civil procedure.
Schedule 1.
It's from the, it was the Jaffray case that I was
Section 1,
referring to.
Section 1, my lord. Rules of court governing the practice and procedure
I see.
to be followed in the High Court. Section 1.1.
And it's in the authorities bundle 393. The Court of Appeal in Jaffray, paragraph 8.
Mm-hmm.
Where it says the CPRB rules of court cannot extend the jurisdiction of the court from that which the law provides, but can only give directions as to how the existing jurisdiction should be exercised. That is very trite law, if authority is needed for the position to be found.
Not trite enough to be clear here. Yes, very good. That's the House of Lords.
Yes, sorry.
That's all right then. Yeah. But sorry. If we go back to CPR Part 39, the wording of paragraph 4 is really interesting because it says the court must order that the identity of any person shall not be disclosed. And this is an order against the world. Must order that the identity of any person shall not be disclosed if and only if it considers blah, proper administration of justice and protect the interest of the person. But presumably it's envisaged such an order is contra mundum.
Lord, yes, that's the practice direction. I sort of only partially went to it in my oral submissions, but there's a practice direction from Lord Newberger in 2010, headed Practice Direction Non-Disclosure. We draw attention to Suskella's argument. And the practice direction includes, I think it's clause 7, which provides for a reporting restriction order set out in those terms. It's, I think,
We're very careful about the language. It's actually a practice guide.
I do apologise.
Because it reflects, it's not intended to actually supplement anything. It's intended really to summarise the existing law. So that wasn't a rebuke at all, Mr. Weir. It was just it's really in your favour.
Well, it's also more accurate. If it's right, it's right.
Yeah.
Thank you. So
What is the relevance of section 7?
Starts at page 123 of the authorities bundle. When you see the language used at paragraph 1, this guidance sets out recommended practice regarding any application for interim injunctive relief in civil proceedings to restrain the publication of information, an interim non-disclosure order. And as we've said before, that's the language used in 39.24. And if you then go to, first of all, they have a sort of draft, an explanation of what it's going to do. It's at page 131 clause 7 bracket reporting restriction, and then if you go on to page 136 to 137, you see the pro forma order, paragraph 7, which is what I'm calling it. It's called a reporting restriction / super injunction. It's reporting restriction order.
Well, it says the defendants. Order against the defendants.
Yes, your lordship's right. I haven't clocked that before, but I think a super injunction is can work against a third party, my lord, and that's page 131, clause 7. This is a super injunction element. It's an optional clause. It's only likely to be necessary, for example, to prevent a respondent or a third party.
131.
Page 131 at D is it's a sort of explanatory clause, if you like, equivalent to that which is then drafted.
Well, it's to prevent the third party being tipped off. It doesn't say it's effective against the third party. I heard about super injunction. It's super difficult.
My lord, I don't have anything, my lord and my lady, I don't have anything more to say about the jurisdiction.
Yeah.
I'm very conscious of the time.
Yes.
I have dealt with the position on evidence in my written submissions with reference to Abassi and put forward some proposals as to what evidence may be required, which reflected the stage at which the application was made. But in principle, I say there should be specific evidence, but I entirely agree with my lord that that this specific evidence may only need to be details about the case. And in fact, the list that I set out, certainly in the context of an application for approval, was very much quite basic details about the case itself, as opposed to going beyond that.
So you don't think we should be overruling Dartford?
No. I mean, the key passages, as my lady has pointed out in Dartford, do emphasise the need for each individual case to be looked at. It's not saying that there is automatic entitlement to anonymity, and I agree with that. It also seems to me that it will depend on the nature of the case, and I would agree with my lord's observations about cases involving very minor injuries which are not long-term, where it may not be needed. But again, this is so fact sensitive. I don't think.
And you would presumably agree with Miss Greeny's view that sorry, Miss Proops. Sorry, forgive me. Miss Proops's view that the whole jurisdiction for approval is founded on something completely different from the jurisdiction we're talking about here.
I do, and that's why I dealt separately in my written submissions, with applications that are focused very much on approval, and those which are not.
Yes.
And where the focus would be perhaps more on privacy interest and other matters. And then I think the qualification of that, it said, well, most of these cases do in fact settle. And so it's been suggested that could be taken into account. And I can see that, I know Ms. Proops says that that's inappropriate, but I suppose there is, it seems to me that is a feature that the court could bear in mind in these cases. But obviously one has to be mindful that it shouldn't turn into an automatic anonymity.
Well, I mean, but the point I was really putting to you was that Part 2110 seems to be a very different exercise from either the common law jurisdiction or Section 11 warranting an order prohibiting publication of the name or any other aspect of a case in progress in the King's Bench Division.
I agree.
Yes, and therefore, really that distinction needs to be brought out loud and clear, needs to be very clear whether you're dealing with a pre-approval application for anonymity within the approval process or a or anonymity within the litigation, and the principles are different.
Yes, and that's why I said in my written submissions that when one is dealing with a pre-approval application, there are these, I describe them as general points that the court can bear in mind as to why anonymity is justified, namely the non-discrimination, to avoid discrimination, the various points with which Ms. Brooks made, with which I agree, and obviously those do not apply in the ordinary case that is proceeding.
No, okay, well thank you. Thank you very much. Mr. Ware, you may have your half an hour.
I'm very grateful, Lord. My Lord, just on the issue of the practice guidance, remember the point now. It says the defendants in the draft at page 136, and that's because if you go back to page 134, you'll see that it's got defendants BBB Newspapers Limited and personal persons unknown. So it is actually anticipating a reporting restriction order which may be against personal persons unknown.
Not necessarily, but might.
No, not necessarily. It's everything's deeply sensitive.
Typically, people bringing these claims don't want to serve the order on anyone they don't need to, for obvious reasons.
Makes sense.
Easily disclosure of the story, but sometimes they do.
My Lord, yes. So that I accepted yesterday, my Lord, that CPR 39.24 cannot alter the contours of open justice as understood at the common law, because the principle of open justice is a principle of constitutional importance, an aspect of the rule of law, C, A and BBC, and as such, I would, for my part, readily accept that as a part of the substantive law of the country. And our submission is different. Our submission is the fact that 39.24 exists in the terms it exists as understood by no less than Lord Newberger to incorporate the right, where appropriate or necessary, I should say, to make a reporting restriction order is confirmatory of the common law position which we say pertains in any event. See also its use by Lady Hale without any difficulty in the R(C) case. That was one of the cases I took you.
In which one?
R(C). It was the case I took you to yesterday, my lord. It was the case involving the person with mental health issues who sought to be released on day release, wasn't released by the Secretary of State, brought judicial review proceedings. And the issue of the anonymity of the applicant or claimant was resolved under 39.24. I'll give you the actual passage again. So it's page 655, my lord, is para 36. And then leads to an answer which is set out at 37 and following. That's the case in which I made the submission, Your Lordship may recall yesterday. I couldn't identify in this an order that said this is an order that is an RRO as well as a WO, but one of the submissions I'm going to make shortly, that they do run together. It would make no sense at all for it only to have been a withholding order in circumstances where there had been previous publicity in relation to the claimant. See paragraph 10 at page 647. Can I start, my lord, by seeking to respond to the very informative submissions of learned friend, the advocate, to the court, particularly by going to Wolverhampton at paragraph 34. So it's page 1100, my lord. I seek to draw the distinction which your Lordship has repeatedly reminded us to draw between the order that's made and the issue of whether somebody is in contempt of court, because contempt of court is its own area of law. But first of all, we have the scope of any power to make an order. Paragraph 34 in that sense can be seen in two parts. The first part is as clear as it needs to be that Lord Reid is explaining a reporting restriction order is a prohibition directed at the world at large. First sentence. And then as you carry on, they're not injunctions in the same sense as the orders which are our primary concern, but they're relevant as further examples of orders granted by courts restraining conduct by the world at large. There can be no mistaking that is not simply an order against another party to litigation. And then separately from that, Lord Reid has addressed, if you like, in passing, the issue of contempt of court. That is a separate issue. To which he attaches the reference AG and leveller. So that should be seen in those two parts. Can I then take you...
Well,
yes,
I suppose you say it makes three distinctions. A distinction between reporting restrictions under the common law power, reporting restrictions granted by injunction in equity with which his case was concerned.
Yes, my lord.
And contempt of court.
Yes, my lord. Absolutely. Can I then just go to Abassi and to the conclusion section in Abassi? It starts at page 1278, paragraph 182. So down at the bottom, 1821, the High Court has jurisdiction in proceedings concerned with the withdrawal of life-sustaining treatment of children to grant injunctions protecting the identities of clinicians and other hospital staff involved in that treatment, where and for so long as that's necessary to protect the interests of those children. That jurisdiction arises under the court's inherent parens patriae powers. Now, just pausing there, that is all absolutely right and all absolutely not this case. I fully accept and understand that. And under its inherent jurisdiction to protect the administration of justice. That is the separate point which I've sought to make repeatedly in relation to the court's powers or role in controlling its procedure in maintaining the effective administration of justice. And it continues, such injunctions can be granted against parties who will not themselves act wrongfully, where that is necessary in order to protect the children's interests, that's your parens patriae jurisdiction, or the administration of justice, and they can be granted contra mundum. That is of a piece with all of the submissions, respectfully, we've made. That is explaining that this administration of justice is its own basis. And I'm not going to rehearse all of the parts of A and B, B, C, etc. in support of that. Its own basis. So I had taken you at some point, as I'd certainly intended to take you, to that part. It's page 1245 to 1246, when this concept had been introduced by Lord Reid. This is in Abassi at paragraph 61, by reference to a judgment from Lady Justice Hale. And you'll see down at H. So
sorry, I'm sorry, I'm behind.
1245 H, my lord. Para 61.
Yeah.
In re S, Lady Justice Hale concluded after reviewing the authorities that such orders can be justified either on the basis they're necessary to protect the interests of the child or on the basis that they are necessary to protect the administration of justice. And then you see over the page at the top, that objective will be jeopardised by the proposed publicity, and this might be said to threaten the effective working of the court's jurisdiction. It's another turn of phrase similar to the frustrating the court's process. And so that was identified, albeit through a family case. That doesn't matter, because as I sought to submit yesterday morning, put the criminal jurisdiction to one side, please, because that's the Crown Court that doesn't have an inherent jurisdiction. But in all civil cases, family, court of protection, ordinary civil, the administrative court and so forth, it doesn't matter. The judge is concerned with the proper administration of justice, so it applies across the board. And that guidance you see in 1281821 covers this case.
And in VC is the case you just referred us to?
No,
No.
that was in Re-S, whereas it was R bracket C was the...
Okay, so in Re-S is in the bundle?
No, my lord, but it's...
This is the Court of Appeal of the one that went to the House of Lords and was considered to be old news in Havasi, but
Yes.
that's the case, isn't it?
But it's you have what's needed. What Lord Reid is doing is using it, if I put it this way, as a vehicle to introduce the relevance of the administration of justice, and he picks up on it not only in that conclusion section, but I have the references marked up somewhere in here. Yes, paragraph 140 at page 1267 between F and G. The court can also grant such an injunction under its jurisdiction to ensure the effectiveness of its orders in respect of the child's treatment. This is the same concept, and if you go to page 1274, paragraph 165. If I'm not going too fast, it's page 1274, para 165. Turning next to the judgments of the Court of Appeal, we respectfully agree with the Court's conclusion the High Court had inherent jurisdiction to grant the injunctions at the outset of the proceedings under its parens patriae powers. And, does your Lordship see this? Para 165. And could also make such orders as it considered necessary to protect the integrity of the proceedings themselves. Really couldn't be clearer. And. When the court, if I'm not rushing ahead,
Yeah.
When the court is considering the common law jurisdiction to make a reporting restriction order, I am at pains to emphasise, please, that it is not just to ensure that there isn't a frustration of the court process. That is obviously highly important. The court also takes into account the interests of others. See paragraph 41, the guidance provided to Lord Reid in A and BBC. See also, for all the reasons I've just given again, CPR 39.24. So that provides that the court must order the identity of the person shall not be disclosed if and only if it considers non-disclosure necessary to secure the proper administration of justice and in order to protect the interests of any person. So all of these factors need to be taken into account. It's not just a RRO under the common law to pursue the administration of justice. That's all I'm seeking to emphasise at this point. A related submission that I'm not sure I've fully made yet is that when considering whether to make an RRO, the context in this case, as is commonly going to the position, is critical, namely that the RRO is made ancillary to the withholding order in order to give effect to make effective the withholding order. I'm not saying, therefore, the court blindly orders a reporting restriction order whenever it orders a withholding order, but I am saying that if the party has persuaded the court that it is appropriate for there to be a withholding order, the party is well down the track, if I can put it that way, to also persuading the court that there should be a reporting restriction order, because the two march hand in hand. So it shouldn't be just seen in isolation, in splendid isolation. It's not to be understood in splendid isolation. And Mr. Justice Nicklin understood this point, I think, page 288 to 289 of the core bundle. Paragraph 49. If a withholding order is made, this will usually prevent the withheld name being discovered as a result of proceedings. However, such an order on its own will not prevent the relevant person being publicly identified if his or her identity is known or can be discovered. For that reason, it is usual for the court to make, or to be asked to make, a withholding order. It's unusual, sorry, for the court to make a withholding order without also imposing a reporting restriction order. Para 49. To the extent that my learned friend for the respondent submitted that PQ involves the equitable jurisdiction, and our respectful submission does not. PQ is a common law inherent jurisdiction case. The case was alive, the case was proceeding. It's exactly, excuse me.
Do we get any help from Scott on Scott itself as to the scope of the jurisdiction to derogate?
Not in my respectful submission, the way which is particularly productive here.
Okay.
It's referencing lunatics and the like. The language has moved on, the times have moved on. We get the qualifications or exceptions which are identified by Lord Reed in A and BBC. It's like the updated version.
Yeah.
Well, I say it's a case of considerable importance. A and BBC really is. And I should add, I forgot to make this submission, that I respectfully endorse what I understand to be the effect of my Lord the Master of Rolls' observations, namely in substance that we're dealing with the common law, and the common law is sometimes described as protean, or it develops, and one must always understand that when it is not fixed in aspic, and that was the force of the observations, if I respectfully say so, in recognising that times change and that open justice is a considerable intrusion now, more considerable than it has been in the past. That's not to say it's not important, it's just to recognise that there are times when it is appropriate to qualify it. And something else which Section 11 of the Contempt of Court Act can be said to do is to recognise through parliamentary action that it is not so offensive in the right case where it is necessary to do so, to make a reporting restriction order against the world at large. Back in 1981, that was deemed to be acceptable and appropriate in order to avoid a contempt of court. When the court is reflecting upon the relevance of the securing the proper administration of justice, there are at least two limbs to this which are separate. One of our limbs is the limb that I sought to describe shortly before lunch yesterday, which is the need to ensure that the award of damages reaches its sort of rightful place, which is to be there and available to the claimant for the remainder of his life to meet his reasonable needs. And if he is financially exploited, that outcome will not be achieved. The other is to put the claimant in a position where, if and when the claimant settles his case, the claimant can proceed to an approval hearing with the real advantage that an anonymity order would then provide, as opposed to the theoretical but illusory advantage that it will provide in circumstances where the claimant has been notified before he settled his case that he's about to receive a lot of publicity. And no more than any other party or intervener do I say that that is determinative. I do not say that is a relevant factor. It goes into the mix with the other factors, the claimant's vulnerability, the huge invasion, understandable but nevertheless huge invasion on his privacy and his risk of exploitation. So, my Lord, I also would draw the distinction, and this has been our submission throughout, between the application for anonymity made after settlement of the case directly in advance of the application for approval by the court, and any other, normally therefore earlier, application for anonymity. To take your Lordship's extreme example of the broken finger, the reason that in our cut to the essence, the reason that the Court of Appeal in Exeter and Dartford was respectfully right to make what I'm going to call a general rule, but I probably shouldn't use the word rule because it is undoubtedly fact-centred, but a general position that there should be anonymity in all those cases, including the broken finger for a few £1,000s, is not because, not by reference to the risk of exploitation based upon the amount of money, it's by reference to two essential factors. One, the court is operating with a different hat on. It's operating its protective role or function at that point. And two, there is otherwise unfair discrimination against the protected person who has to go to court to obtain approval in circumstances where an adult with capacity does not. And that's why it applies to the broken finger claimant as much as to the grievously injured, of which this is a paradigm, grievously injured claimant at the most severe end of the spectrum. And that's specifically in relation to anonymity linked to approval. So far as concerns an application such as this one for anonymity in advance of settlement of the claim, we have never sought general guidance from the court, other than to this degree. We would invite the court respectfully to adopt and follow the guidance which has been given by Lord Reid at paragraph 41 in A and BBC to explain, obviously, the test is one of necessity, that the person applying bears the burden of establishing it, no question about any of these matters. That then there is a balancing exercise as all of the factors need to be taken into account, such as are set out at paragraph 41. And then the court is certainly common ground between the parties, although the court, I don't think, is bound by my learned friend's position in relation to there being an inherent jurisdiction to make a reporting restriction order. I expect this court could still ignore the, if you like, concession by my learned friend that Mr. Justice Nicklin was wrong on that and still find that there was no such inherent jurisdiction. But in any event, if the court adopts the position of both parties to the appeal, namely that there is a common law inherent jurisdiction to make a reporting restriction order, then this court is now required, or at least we would invite, you're never required, but we would invite you not to remit the matter, not just because it will delay matters, but because we would benefit from this court's assessment on the facts of this case. And actually, once there's been the only guidance that can be given, which is to acknowledge the balancing exercise that needs to be performed, this court's performance of that exercise and whether or not this court takes into account and the weight it attaches to the matters on which I've already made submissions, such as the damage that will be done to a subsequent application for anonymity attached to an approval application, and the significant risk that the purpose of the court's order for damages will be frustrated, namely to ensure that the claimant has damages which will meet his reasonable needs for the remainder of his life. The extent to which the court accepts and adopts or applies in its own way those matters will itself be guidance in the future. And sometimes this idea for a one-hit wonder, in my respectful submission, is asking too much. This court doesn't need to provide some form of encyclopedic guidance. It can't. The matter is fact-sensitive. We go back to paragraph 41 in AMBBC. Lord Reed says so in terms. And I expect, speaking only for myself, that what will happen is there will then be a number of first instance judgments in which judges will choose, when there is an anonymity application, to provide a pretty detailed judgment. This is an anonymity application in advance of settlement of a claim, so not the Exton Dartford type application, but there will, in any case in which there is another application, there'll be a pretty detailed judgment, which I doubt actually there'll be appealed, but it's possible there'll be appealed. I expect there'll be a series of first instance judgments, and we'll essentially have a body of case law, all tracking this judgment, which will be, if you like, the source, but it doesn't have to provide guidance specific to those individual cases. And to exaggerate, to make a point, if there is some application in relation to the broken finger, then if that application is dismissed, no doubt the reasons will be provided that will guide people in the future. But again, it will be limited to the facts of that case. That still provides guidance of that nature, rather than this almost impossible task that courts are sometimes invited to enter into, which I would caution very heavily against. Well, my Lord, unless I can assist further, and with gratitude for allowing me to carry on 3 minutes beyond 4:15, those are our submissions.
Thank you very much, Mr. Weir. Well, thank you to all the advocates and to the solicitors. This has been a very important case, and it's been well argued. Thank you very much to all advocates. We will take time to consider our judgments, and I do not expect that you will get them before the long vacation. And I'm not particularly grateful to you for the listing date, because it may bother me in the long vacation, even if it doesn't bother you in the long vacation. But we will take time to consider the important decision. When you get the judgments, you'll get them in draft. I don't think it's so controversial that we don't need to give it to you for corrections, but please only correct typographical and uncontentious matters, and don't use it for any other purpose except agreeing costs and the order in accordance with the embargo referred to in paragraph
35.
Thank you. And any disputes about disposition we'll deal with in writing. Thank you all very much.
All right, table.